Hey, yes indeed, it is she, attorney Shequel Ross here from SHElaw firm. So today, like I promised you guys, I'm going to be talking to you guys about criminal warrants. Warrants, right? Okay. Where do warrants come from? The warrants actually come from the Fourth Amendment of the Constitution. And the Fourth Amendment states that citizens have the right to be secure in their persons, their houses, their effects against unreasonable searches and seizures, and they shall not be violated, and no warrants shall issue but upon probable cause. So I'm getting ready to break this down to you guys. Basically, when an officer needs a warrant, why they need a warrant, how they need a warrant, how they have to serve the warrant, and it doesn't matter if it's a trap house, if it's a bando, if it's mama's house, if it's grandma's house, if it's the local trap queen's house, it doesn't matter. Like I promised, I'm getting ready to give it to you guys raw. So that's what it is. I'm just kicking knowledge out to you. So if the officers come to your house and they say, hey, I'm trying to get into your house, I'm trying to, we need to do a search, I need you guys to understand what that warrant has to say. I need you to understand what that warrant has to display. I need you to understand the particular details that that warrant has to show in order for that warrant to be valid, okay? So basically, like I said, warrants come from the Fourth Amendment of the Constitution. And it protects everybody. It protects things. It protects your person. It protects your purse. It protects your house. It protects my shoes, right? It protects everything. It doesn't matter. It protects the pouch in front of my bicycle. It protects the pockets. It protects everything because the Fourth Amendment says it protects persons, houses, papers, effects against unreasonable searches and seizures. It can't be violated, and no warrant shall issue but upon probable cause that must be supported by an oath or affirmation. And it must particularly describe the place to be searched and the person to be seized. Okay, so let's just get right down to it. What does all that mean, right? What does the Fourth Amendment mean? What does all this mean in terms of what a warrant must say when an officer comes to your house and says, hey, I have a warrant? You know, they knock at the door and they say, I have a warrant. Okay. So in order for the cops to search, they must get a warrant, right? What do the cops have to do to get a warrant? They need to be able to show probable cause. What is probable cause? You know, that's like a fancy word. People always say, do you have probable cause? What's your probable cause? Probable cause is basically a logical belief that the circumstance is showing that there's a crime being committed or about to be committed or a crime that might have already occurred. That's what probable cause is. It's the standard a little bit higher than reasonable suspicion, because reasonable suspicion is just an articulable belief that maybe a crime might be happening. Probable cause is that it's like a logical belief that something is actually occurring or did occur or about to occur. So what happens? The cop goes to a magistrate court and tells a judge, hey, I have probable cause to think that a crime is being committed, a crime has been committed, or a crime is about to be committed, right? And then basically the magistrate judge signs off on what is called an affidavit. Right? What are things that actually equate to probable cause? It can be an observation by the cops. So let's say they see something happening. It could be circumstantial evidence. It could be someone actually saying that they're guilty of something when the cops show up. It could be neighbors, witnesses. It could be gestures. It could be tools of an actual crime. It can be victims. It could be informants. You know what those are called? They're called snitches, right? We call those snitches. Informants are called snitches. That's a fancy word for a snitch, right? So an informant says, hey, you know what? They're wired up. Their officer is I have a wiretap case right now. An officer is listening in with the informant. The informant is snitching, helps setting up the scene with the officer. And basically the officer gets probable cause to think that a crime is getting ready to happen. Okay. It could be what the officer sees. It could be what the officer smells. Like when he comes to your car and says, hey, this is a traffic stop, but I'm going to arrest you for marijuana, right? He smells marijuana. Okay? Or guess what? If you give consent. Okay? So now, if the officer thinks that probable cause exists, then the officer is going to go to a magistrate court. You know, so in Georgia, it's called a magistrate court, right? So basically, he's going to fill out an affidavit with an oath, right? An affidavit and an oath that tells the judge why he needs the warrant. That's all it is. Hey, judge, I have this snitch telling me this. I have this over here. I saw a hand-to-hand transaction. I saw this. I saw marijuana being cooked at the trap house. Marijuana can't be cooked. I don't know, but if you're from Arizona, I'm just joking. But anyways, he goes to the judge and he says, hey, you know, I have probable cause to believe that a crime has occurred at this place. The magistrate judge then signs the actual warrant, right? What is an affidavit? An affidavit is just fancy words for a statement under oath. The officer is saying, hey, under oath, I am saying that I believe that this crime has occurred or this crime is about to occur. It's under oath. He fills out an affidavit and it's under oath. The judge then signs it. So what is an example? What is an example of an affidavit? So this is what an affidavit would state at a magistrate court. It would say the undersigned, which is the officer, being duly sworn in, deposes and says that I am sworn in as an officer, post-certified under law, an enforcement officer in the state where you're at, here, Georgia, charged with the duly right to investigate criminal activity and enforce the criminal laws of this state. This application, which is this affidavit, he's gone to the magistrate judge, right? It's an affidavit saying that he believes that there's probable cause that a crime has occurred. He's trying to get a warrant. So this application for a search warrant and my affidavit and oath support this, right? And I am making this sworn affidavit setting forth that probable cause exists. Okay, so this is an affidavit that the officer goes to the judge and says, hey, there's a crime that might be occurring, that could be occurring, or that has occurred that gives me probable cause to get a warrant. Okay, so then there's probable cause to believe that a crime has occurred. The judge issues the warrant. He signs the warrant, right? I want you guys to see what this actually looks like, what a signed warrant looks like. So when an officer comes to your house, you know, they knock, right? They knock. And they say, hey, warrant, open up. When you get the warrant and they say, hey, we have a warrant, the warrant should have the judge's signature. Okay? Can't do it too long because I don't want you to see what case this is. But the warrant has the judge's signature. That's how you know whether or not the judge signed the warrant. The judge signed the warrant and the affidavit that he swore under oath that he can now execute the warrant at that place. The judge signs it. So if an officer comes to your house and says, hey, we have a warrant, the first thing you should be asking for is the warrant. You want to see if the warrant has been signed by the judge. This one has, okay? So let's keep going. So the judge signs off on the warrant, but guess what? It has to be a particular place. It has to be a particular place that the officers think that this crime is going to occur or has occurred or might occur. He can't just say, okay, at this house over here, but then try to get into a car at the actual house. No, okay? It has to be very particular because the Fourth Amendment says it has to be particular, okay? So what are some particular ideas in regards to a particular area? In this one, this is how particular it is. It says the entire premises, right, located at this place includes the properties, includes the parties, includes the multifamily dwelling. It's a 3-story structure. It's trimmed with yellow. It's a single roof. It's at 1920, blah, blah, blah. It's a name on the front. The mailbox is this color. It's in the middle of the building. The letter M is on a white box. There's a car in front of the door. So these are all particularized facts that have to go inside the warrant, right? So because the warrant has to be particularized. So this officer and the judge said, okay, you know what? You swore it in. It's particularized. I'm going to execute the warrant. Now you can go serve it. Okay. So now what? Now the officer has a warrant. He comes to your house, and what must happen, right? What must happen when the officer gets to your house? Some states say that they have to knock and announce. So check your local rules. An officer shows up at your house, check your local laws. Officer shows up at your house and says, hey, I have a warrant. Knock and announce means that some states say, hey, you don't have to knock and announce. If you see somebody in there that is the evidence of a crime, or somebody that has committed a crime, and the officers can see directly inside that house, they have reasons to go inside and get you. But let's say, for an example, some states, there is a knock and announce rule. The officers must knock and announce who they are. Okay, so it's called knock and announce. What must happen? They must give you a chance to come to the door. They must give you a chance to get dressed. They must give you a chance to identify who you are. You could be visiting. You know what I mean? You could be in the trap just visiting. You in the bando just stopping by to say hi to somebody, right? And you get caught up. No, you have to. They have to give you a right to identify yourself. Okay. They must present the warrant. They must say, hey, I have a warrant. And you already know, because I already told you guys, anytime an officer comes to your house with the warrant, they must be able to show the warrant. And you are going to ask to see the warrant, and you're going to see whether or not a judge signed off on the warrant. Okay? So also, they must respect other occupants. They cannot refuse to allow you to get dressed. You understand what I'm saying? If the officer say, hey, I have a warrant, we're coming in, you can say, officer, hey, I'm not dressed. Officer, it's 2 a.m. in the morning. Let's say, for an example, this is in Arizona and they put you in a hot garage. This is happening, right? I'm getting calls. This is happening all over. The officer goes to the scene. They arrest somebody. They say they have a warrant. They go in. They execute the warrant. They see maybe 10 people there hanging out, a family. They put everybody in the garage. There's people dying in Arizona because it's 122 degrees. We have heat advisories. Okay, so it is unreasonable. Like I said, the Fourth Amendment says searches and seizures must be reasonable, right? It's not enough just to say that an officer has a warrant, that he's gone to the magistrate judge, swore under oath in an affidavit, got the judge to sign off on the warrant, and now he's executing the warrant. He also has to be reasonable when executing the warrant when he gets to your house, right? So it's unreasonable for him not to let you get dressed. You're standing there and you're naked. It's unreasonable for you to be in a hot car or a hot house and him refusing to let you get water, and it's 129 degrees in Arizona. It's unreasonable in Michigan, where I went to law school, for them to have you outside in the snow in -18. Yeah, I remember those days, okay? So it has to be reasonable, right? And when you hire an attorney, that's exactly what we look at, whether or not the reasonableness factor was executed when that officer served that warrant. Okay? Let's keep going. They cannot refuse to show you the warrant. I got a lot of calls on this. You know, people are saying, hey, they came to my house, they bust in, they didn't show me the warrant. They can't refuse to show you the warrant. You understand what I'm saying? They're going to try to do it. It makes a good argument for a defense attorney, but you have the right to ask for the warrant. If they say, I'm not going to show you the warrant, then of course there might be an action for motions to dismiss. And please understand that if the warrant is defective, or if there is some type of unreasonableness factor, or there's other case law that is governing what your situation, what has happened in your situation, you could possibly file for federal damages under an act from 1983. It's a federal act. You can get certain damages if they wreck your house, if they tear up mattresses, if they tear things up. So all you have to do, just take note. You don't have to try to argue with them. You don't have to do any of that. So let's keep going. So let's say, for an example, they're executing the warrant, they're walking around, they're getting things out of your house. They have to keep what is called an inventory, okay? An inventory is basically exactly what they found at the house, right? So they get to the house, they say they have a warrant. They give you the warrant, and you're gonna ask for the warrant, because if you don't ask for it, they don't have to show it to you. So you're gonna ask for the warrant. Once you ask for the warrant, you're gonna see that the judge has signed off on the warrant. Like I said, the judge has to sign off on the warrant. While they're there, they have to be taking inventory of what it is that they're getting. They can't be getting your limited edition Jordans that have nothing to do with the drugs that they saw over here that's cooking in the pot. You understand what I'm saying? It's particularized according to what they think that the crime, the evidence of the crime is, the circumstances from the crime. They can't be in the garage snooping around in drawers looking for bicycles when they're there conducting a police raid or conducting a raid on a house. You get what I'm saying? For drugs. So this is an example. This is a case I have right now. I have a lot of drug cases. So this is a case that I have right now. This is an inventory of what an inventory is in regards to what the officer has to keep track of. I have 9mm magazine with 7 rounds Glock, undetermined amount of U.S. currency, and they have to say where they got it. So under this is the inventory side. On this side is the location it's found, and on this side is the officer. So this is saying that it's about probably 23 things, from digital scales to black AK-47s to red Adidas backpack. It must have had drugs in it. I'm not sure yet. Approximately 113.2 grams of white powder in a plastic bag found in the dining room, a plastic bag, assorted pills in a shoebox, bedroom, a Glock 22, a magazine, I almost said Draco, excuse me, a PT 145 magazine with 9 rounds, a Taurus 45, Alabama ID, a New York ID, a 5.56 bullet in a shoebox, a silver range, a Glock 40. I mean, yeah, this is what I deal with, right? So, and this is 2 pages. It's over probably 80 or 90 things that are found in this house. Like I said, they have to show you what the warrant says, what the warrant allows them to check, and they have to keep an inventory of all the things that they took. So let's say, for an example, they say, hey, you know what? I have a warrant. Here's the warrant. They show you the warrant. We know they have the warrant. Then they're in the house. They're keeping an inventory. And let's say, for an example, somebody is there randomly. Or let's say I'm there visiting you, right? And all of a sudden we're in a drug raid, right? Am I allowed to get my property back? Let's say if they want to collect this necklace, has nothing to do with it, but they think that the necklace that maybe I took off and is right next to me is part of the crime. Am I able to get my necklace back? There's a process that you have to go through at the police station. If those things don't relate to a crime or evidence, there is a process that you can go through to get your items back, and that you will have to contact an attorney, because they just start seizing things. They don't know if it's part of the evidence or if it's not. But if it's part of the evidence, you can't get it back. But there's things that we can argue in regards to getting it back. We have a question.
Yes, Antonio from Phoenix asks, I jumped in because you just talked about this. Can the clothes that I have on be requested? And if so, do they watch me change clothes?
Okay, so Antonio from Phoenix, where I'm from, he's asking, can the clothes that he has on be requested? You know, that's a tricky one, because there's actually case law that says, let's say, for example, this is a rape, you know what I mean, or a murder, and there's bloody clothes on you, and you have to, their DNA has to be collected off those clothes. It all comes down to the reasonableness. The officer can't sit there and watch you change. He has to allow you to go in the bathroom, change your clothes, and be able to give those clothes. But you know what I would suggest? Before you go taking clothes off, giving the officer clothes because he thinks it's part of a crime, I would suggest you call an attorney. You guys already have my number, Antonio, 855-5-SHElaw. Because I'm going to make sure that your rights are protected. You know, you can incriminate yourself. So be careful when it comes to that. Ask to call an attorney on the scene. We have another question?
Yes, Tim from Douglasville asks, do I have the right to have my attorney present during a search warrant being executed?
It depends, Tim.
Mm-hmm.
It depends, Tim, because under certain exigent circumstances, if the police officers think it's an emergency, or if the police officers think that the evidence may be destroyed, or if the police officers think that you might run away, they might not allow you to call your attorney. But let me explain something to you. I have had probably 20 calls when the house is getting raided. People call me on the spot during a standoff, during a negotiation, during a warrant, during a SWAT. People call me, and let me tell you, I would say the answer is yes, because it depends on your attorney. I have favor. You get what I'm saying? And I'm a negotiator. I'm a licensed mediator, and I know how to negotiate. So it just depends on that attorney and how he can, lessen the situation. But I would say, yes, you do have a right to an attorney. Okay? So let's get back to what I was saying. I hope that answers your question. So they present you with an inventory. You would be able to go to your local court to get a copy of that inventory list. And the inventory list basically is attached with the affidavit and attached with the warrant. And it says here, it says, I, the officer, received a search warrant from the judge. This is what the officer is signing. That set forth that I did, he checks the box, I did execute the search warrant, and I'm filing the return as inventory. Like I said, this one has over 40, 50 things, guns, drugs, one of my clients, about what they found. And that it has the time, the date, and it also has that he checks the box if he did this. It says, I left in a conspicuous place on the premises described in the warrant on the living room table the following inventory, right? So he leaves a copy of this inventory list, and he also files one with the warrant and with the affidavit at the local court. So I have a lot of cases like this where they take certain things and the things aren't written on here, right? Let's just be honest. Sometimes there are dirty cops. Now, shout out to all the amazing, wonderful cops out there. But let's say, for an example, they take $50,000. I have a case like this right now. They took $50,000, but they only wrote on here that they took $20,000. They tore up mattresses. They tore up TVs. They tore up refrigerators. Like I said, if that search is unreasonable, if that search is outside the scope of the Fourth Amendment, if that search is outside of the particularized description of what the warrant would have allowed for in that situation, you can get damages. You don't have to be afraid to sue the police. If they go outside your constitutional right of the Fourth Amendment, you would contact an attorney and you would file a lawsuit under federal law, so you can get damages for what it is that they did or destroyed. Okay, so you would need an attorney to look at that to make sure that's appropriate. Okay, so let's keep going. Now, there might be exceptions to the warrant. Like I said, the Fourth Amendment says that you have the right to be protected in your house, your persons, your things, my office, my purse, my bag, my shoes, my bag. It doesn't matter. Persons, houses, things, and effects. It covers everything. Underneath my ring, it covers everything. But let's say, for an example, like I told you guys, there's situations that don't even call for a warrant, right? There's exceptions to an officer having to go to a magistrate judge and get a warrant, right? Some of those exceptions are a search incident to arrest. You're driving down the street and the officer pulls you over for a traffic stop, right? He says he smells marijuana. Now, you guys already know my theory on this. You're not going to roll the window all the way down. This happened to me as well. This happened to me as well. The actual officer asked me to keep rolling my window down. And I'm like, okay, why am I rolling my window down? I've already given you my license, my registration, and my insurance, right? So he's going to say he smells marijuana. I don't even drink. You don't smell marijuana. Is the traffic stop over? So let's say, for an example, if he did smell marijuana, I was smoking, which I don't, and he gets me out the car, he searches me. It's called search incident to arrest. He arrests me, and then he can search me. So that's an exception. He doesn't need a warrant. If he has arrested you, he can search you. Okay? A stop and frisk. Let's say, for an example, there's a situation, people are running, the officer thinks he sees something in regards to a drug sale, right? Or he has to particularize, and it has to be more than just him seeing two dudes shake hands or, hand-to-hand transaction. With the totality of everything going around, he says, I think this is probable cause to think that a crime is being committed. Reasonable suspicion. So he can stop and frisk you. This is Terry versus Ohio. He can frisk you. You have pockets. He can frisk everywhere. Can he go inside and start pulling things out? No. He has to have probable cause. Okay, so we said search incident to arrest. They don't need a warrant. Stop and frisk. The third one is automobile exception, where the search of a car or another mobile car, or I have a high profile client right now who's actually a rapper. He was speeding in one of his ATVs, right? They pulled him over, searched him. They thought he had drugs in the actual middle compartment of the ATV. Okay, so that's considered mobile. So yeah, he was that was searched. Now let's say plain view. The officers pull you over and you have crack in the car, right? Or the officers they stop you on the sidewalk. They're just wanting to talk to you. You could walk away. You don't have to talk to the police. You could walk away. Have a good day. But let's say there's reasonable suspicion to think you're committing a crime, and then there's probable cause and they arrest you, right? Before they arrest you, let's say that you have a little tip of a blunt hanging out your pocket, right? So that is literally plain view. They see the blunt, they arrest you, okay? So that's number 4. So search incident to arrest, they don't need a warrant. Stop and frisk, they don't need a warrant. Automobile exception, they don't need a warrant. Plain view, let's say open view, okay? Let's say, for an example, they're walking down the street and they see on the side of the road all these marijuana plants being grown. You know what I mean? Shout out to the 40/20 club. But all these marijuana trees just being grown. That's open view. It's in plain view and it's open view. Let's say plain smell, right? The officer smells marijuana, or the officer smells, in Arizona, we have meth labs. Not so much out here in Georgia, there are actually a rise of meth labs coming up in Georgia. Let's just say any of those things. Now, also, if you consent to a search, the officer comes to your house, he knocks on the door, and he says that he wants to come inside. No, say no. Say no. Close the door. Matter of fact, don't even open the door. When the officer says, hey, can I come inside and search? They're asking you a question. Don't be fooled. Don't get tricked. It's called trickery in the words, right? They're trained to ask questions a certain way. Can I come inside and search your house? Let them ask you through the peephole. You understand what I'm saying? So through the peephole, you're going to say no. You're not going to give consent to help them with their crime or their investigation against you. Okay? Abandoned property. Hot pursuit, right? You're running. They could search you, right? It's hot pursuit. This is an exception under the warrant. An inventory search. Your car is impounded. They could search your car. Exigent circumstances. An emergency. Like I have a situation right now. A girl called the police in her house. The police thought that the girl was a victim of a crime. Okay, the police get to the house, and of course, yeah, they see her with bruises, with I don't know, she had a face patch on. Yes, that's exigent circumstances because they think that she is a victim of a crime. They don't need a warrant. Border searches, like you guys know, I'm from the other A, not Atlanta. Y'all live here, but I'm from Arizona, the other A. Border searches, okay? They could search you at border searches. And school lockers. So all you moms out there, dads out there, aunts, uncles, foster parents, any of you who have kids, your children can be searched. Their lockers can be searched under the 4th Amendment. The officers do not need a warrant. So I would advise you parents, make sure that you know what's in your child's backpacks. I have a case like this right now as well. The officers went inside his locker because they thought that he had marijuana or drugs and tools to commit a crime. They're searching his bag. They pull him out of school. They search his bag. They search his locker. Yeah, they can do that because, like I said, there are situations where an officer does not need a warrant. Okay. Okay, we have another question.
Olivia from Washington is asking how many police officers are allowed in my home at one time.
Olivia from Washington. Okay, so honestly, that would go back to reasonableness. Olivia is asking how many officers can be present or seizing you or searching your house at one time. And I would make that relate back to reasonableness. I'm not sure what Washington's law is on that, and if there's some type of law that says 2 officers need to be in your house or 3 or 1. But like I said, if it's a certain type of attorney, criminal defense, an officer comes to your house, they're telling you that they need to search you and or search your house, and it's 900 officers and it's just you, that might look a little unreasonable. Like, Judge, it's Olivia. She's 22. I mean, why is there 900 officers in the house? So is that reasonable? Is it unreasonable? So I would make the answer be more broad instead of there's 1 officer, 2, 3, 4, or 5. Okay. Let's keep going. Okay, so we have some other questions that have been coming in all week to my inbox all week. And thank you guys for asking all these questions. I mean, like, really, this is like really important. This is really serious, so I appreciate you. One of the questions is, what is probable cause for a search warrant? Okay, we covered that a second ago. Probable cause to search your property or things or houses or effects under the 4th Amendment are facts and circumstances to the cop that would lead a reasonable person to believe that there is evidence of a crime that has been committed, that was committed, or is about to be committed. Okay, that's what probable cause is. It's a fancy word, basically meaning, is there probability more than likely that a crime is getting ready to be a crime has occurred or about to be occurred. Excuse me, a crime has occurred or might happen. There we go. Can you say in a search warrant, like an officer goes to the judge, he has an affidavit, can he base that getting a warrant on hearsay? Now, an affidavit on hearsay, I just want you guys to understand, it can't be used in a criminal trial. It can't. Okay, there's exceptions to hearsay. It can't be used in a criminal trial, but it can be used based on the totality of the circumstance. So a snitch goes to an officer and says, hey, you know what? There's going to be a crime that's going to be committed. This dude is going to be selling meth out of his house. I have a situation like this right now. He's going to be toting meth in dog bags. The officer sees that. The officer goes to the scene, sits in his car, watches in plain view everything that's occurring. He's able to articulate that to a judge. The judge issues the warrant. Okay. Another question. Can the police kick the door in without a warrant? I have a situation like this right now, right? Police going around thinking they could do whatever they want to do. Like I said, you don't have to argue with them on the scene because you're going to call me. 855-5-SHElaw if you think that search was unreasonable. Even if you think it's not unreasonable, when you call me, we'll be able to look at the statute, the federal statute that says whether or not you can get damages, damages means money, compensatory damages, on what they did or didn't do. Okay, so can an officer kick the door in? Now, this determines whether or not there was exigent circumstances, right? Was there an emergency that warranted the officers to kick the door in instead of showing you that they had a signed warrant by the judge? Okay, another question. Can the officers go on private property and look at evidence and try to use that in court? So I'm at my house, right? And they decide, I'm sitting in my house watching TV with my dog Doughboy, and all of a sudden I see an officer peekabooing in my window. No, they can't do that. Now, if there is something on the outside, is there something on the grass or something that they see? Yeah, they can use that. But no, they can't come peeking in my window. That's a violation of the 4th Amendment. It's almost like a search. They're searching, they're looking for something, okay? I mean, it's a stretch, but yeah, an argument could possibly be made. Okay? Can you sue the police officers for an illegal search? Like I said, you guys, yes. The answer is yes. Okay? Yes, you could sue the officers for an illegal search. Like I said, it's a code. It's a section under the federal law. It's a 1983 U.S. code, U.S. So it applies to all states, right? And it means in violation of the Fourth Amendment and according to federal law, you can receive damages. You can receive money for injuries. Let's say they have you all tied up in the back. They have you all tied up in the back of, the back bedroom. You're hurt. They tear up your mattress. They kick the door in. I have a situation like that right now. Yeah, we are filing paperwork for money damages because they violated the Fourth Amendment. Okay. You're a victim of an illegal search and seizure. All of a sudden it was a crime. You're a defendant, but then you turn into a victim. Okay. So basically, let's see if we have any other questions.
We have several comments with people thanking you for the information. That you're the very best. Good information. Thank you, thank you, thank you. You're getting lots of accolades from people on both.
Oh, thank you guys. Yeah, I appreciate all the feedback. You guys, all week, you guys have been sending me questions. You've been overwhelming me. But I'm getting it all back to you. So don't worry. Anything that you want to know when it comes to anything, I don't care what it is. I don't care if you want to know something about can an officer take your dog, right? I have a situation like this right now. This case is on the news where the officers pull up to the scene. They think that my guy's in the house. He's committing a crime. My guy's dog runs out. The officer shoots not shoots the dog. The dog runs out just to look. The dog runs back in the house. The officer decides that he wants to shoot the dog. Right? Like, that's crazy. The dog came running back in the house. So my clients had to bury their dog. And it wasn't even the right house that they were serving the warrant on. Right? So of course we're going to file damages. Of course, under federal law, they violated a Fourth Amendment search and seizure constitutional right that my client has. And now he has a dead dog. You see what I'm saying? So yes, if it's any situation that you think, you call me 855-5SHElaw. You inbox me. You do whatever you have to do, and I will make sure that either I, my team, or my staff get back to you. So I hope this answered all your questions, but let's do a quick recap, right? So basically, I don't care what it is. I don't care if it's a trap house. I don't care if it's a drug house. I don't care if it's your grandma's house. I don't care if it's your third wife's house or your wife. I don't care if it's the pastor's house. I don't care if it's a church. I don't care if it's a friend's house. I don't care if it's your purse. I don't care if it's underneath this tape. I don't care if it's your bike. I don't care if it's my hair. I don't care whatever it is. Your person, which is your body, your effects, which is your things, any of your things. They can't even search inside my laptop. They need a warrant for that. Okay, your house, it doesn't matter. Trap house projects, it doesn't matter what it is. White House to a trap house. You get what I'm saying? It is protected under the Fourth Amendment. And the Fourth Amendment protects you against unreasonable search and seizures. The officer has to go to magistrate court to apply and get a warrant, right? He has to have probable cause to think that a crime has been committed. What's probable cause? More than likely that a crime has or is about to happen or has happened. He goes to the magistrate court. A magistrate judge signs off on the warrant. Now he has a warrant to execute it. He goes to your house with the warrant. The warrant, you're going to ask to see it. The warrant has to be signed by a judge. The warrant has to describe the particular places to be searched, the items to be seized, the address, the location, what it is that the officer thinks that he had probable cause to think that a crime had been committed. It's going to be displayed, right? So you're going to ask to see it, okay? So what happens? He gets there, you're not dressed. You ask to be dressed. He gets there, other things are occurring. It has to be reasonable. This search has to be reasonable. He cannot go looking. If it's drugs, yeah, it's small. He possibly could look everywhere. Let's say he's looking for stolen bikes. He cannot go looking for a stolen bike inside of a drawer, inside of your refrigerator. That's not a stolen bike. You understand what I'm saying? Okay. So basically, just always remember this. Anytime an officer comes to you that says that they have a warrant, ask to see the warrant. So that way you know exactly if the warrant was signed by a judge. Okay? And then there's exceptions that prevent the officer to even get a warrant. Like I said, we covered those. There's 10 of those. And just make sure you always, if you have any questions, reach out to an attorney, because there might be situations and case law. There's lots of case law that govern these things. And this is how attorneys get cases suppressed in court. Okay? So hopefully this answered all your questions. Do we have any more questions? So hopefully this answered all of your questions. Continue to inbox me, continue to write me, and I'll make sure I answer your questions. Don't forget, you guys, on my website, www.SHElawfirm.com, I have on there your free Miranda cards. So you can log on, you can get your wallet size Miranda card. It's free, okay? You print that out. If you get stopped, you get pulled over, you're going to give your license, your registration, your insurance, and your Miranda card, your SHElaw Miranda card, right? So you don't have to say nothing. I have it all printed out. All you have to do is pull it out. You get pulled over. Well, first you print it out. You get pulled over. You pull it out, right? Okay? And basically follow me on IG and Twitter at SHElaw Office. On YouTube, Shequel Ross. All these videos are there in case you missed something. Facebook, Shequel Ross. And my phone number, you already know, 855-5-SHElaw. Bye!